My name is Nicholas Warner, and I'm a commercial underwriter based in one of our branch offices in Austin, Texas. I've been with merchants for about 6 years now. My current territory includes Texas, Oklahoma, and Arkansas. And during my time at merchants, I've also helped with Louisiana and Alabama. I'm joined today by Megan Manier. Good morning.
Hi, Nick. I'm Megan Manier, and I've been at Merchants for 6 years in the commercial department as a commercial assistant, underwriter, and now training manager. I've helped with states all over the Mideast, and now I'm the underwriter for our large Iowa agents and the training manager. In my previous life, I worked in property casualty insurance for about 8 years, and now Nick will take you through the first portion of our training.
All right. It's great to have so many people watching, and we look forward to a great training session. Today, we're going to cover an introductory level to commercial surety bonds. And by the end of the program, you'll be able to determine what a bond is, know the difference between insurance and surety, understand how contract bonds differ compared to commercial bonds, what the main pieces of the bond form are, what are the different types of renewals, how does someone apply for a bond, and what an identity agreement is. And then we'll take a 10-minute break, and then we'll come back and cover do sureties a collateral, how are bonds issued with power of attorney, how much does a bond cost, how are bonds underwritten, what are some opportunities, and how do I get in on this with my agency. And then we'll do a conclusion and a mock scenario to try and tie it all together. So I'm sure for most of you, when you heard the word surety for the first time, you had no idea what it was. For me, my experience was a bit different than most. For those who don't know, Merchants Bonding Company was founded by my great-grandfather, and I'm part of the fourth generation to be involved with merchants. One might be able to say I was born and bred for bonds. So even though I've had a lot of exposure to this industry from a young age, I too struggled with understanding what a surety bond is at first. I tried asking when I was younger or just tried to Google the answer, but didn't all click. It wasn't until I got to college, and by luck, one of my courses was going over this exact topic. They gave me the broadest definition. Surety bond is a legally binding contract between three parties that guarantees one party will fulfill their obligations to another party. Once I had that definition and exposure, I was able to go to many of the surety experts here at Merchants Bonding Company to get a more in-depth understanding. They really helped break it down for me and give me a real understanding of how this industry works and all the good it can do. In reality, I shared this story to illustrate that surety is not just something you can Google and become an expert on. To be an expert, you have to first understand the basics, and that's what we're going to cover today. So here's a more detailed definition of surety. Three-party agreement between an obligee, a principal, and a surety. It's a promise by a surety or guarantor to pay one party, which is the obligate, a certain amount. The second party, the principal, fails to meet some obligations, which is fulfilling the terms of a contract. Surety bond protects the obligee against losses resulting from the principal's failure to meet the obligation. This may sound complicated, but if we look at the example and identify our three parties, it will kind of start to come into focus. Common bond request in most states is a motor vehicle dealer bond. This is a bond required by the state for new and used car dealers to obtain and to guarantee, among other things, that the car is clear title, all taxes are calculated accurately and paid to the state, and the customers of the dealership do not suffer losses due to fraud or misrepresentation. So in this example, the obligee is the state, the principal would be the dealership, and the surety would be guaranteeing that the principal or the dealership, in this case, performing the standards set by the obligee, which is the state. Now let's break that down. We'll break down all three parts even further. So the obligee in our example, again, was the state. They require the bonds to guarantee that certain obligations are met by the car dealer. These obligations were put in place to protect both the state and the consumer. The principal, this would be the party bound to the obligee by a contract, statute, or other means to perform the obligations required by the obligee. In this example, the principal is the dealership, and the contract is between the dealership and its customers. It's also a contract between the dealership and the state. Remember earlier in the example, we said that the state wanted the bond to guarantee the cars being sold by the dealer at clear title. And then that would represent a contract between the dealer and the customer. We also said the bond was needed to guarantee that the taxes were collected and remitted to the states. That represents a contract between the dealer and the states. Finally, we also stated that the bond guaranteed that the dealer did not engage in fraud or misrepresentation. That would be a contract between the dealer and both the customer and states. And then the third party, again, is the surety. And that is the company providing the financial guarantee. So to recap, surety is an agreement between the three parties. It's a promise by the surety to pay one party if the second party fails to meet the obligation. And again, those parties are the obligee, who is the party requiring the bond, principal, which is the party required to post the bond, and then finally the surety, which is guaranteeing the bond. Now, we'll move on to our next section of insurance for surety. Many of you listening today have a strong understanding of insurance and deal with insurance on a daily basis. And I'm sure in discussions with your peers or during other continuing education classes, you've heard surety and insurance talked about together. For some of you, this may have even formed an opinion that insurance and surety are the exact same thing. I mean, there are similarities. They are both regulated by the Department of Insurance, and they are both provided by the same provider, and they both require a certain level of underwriting. In fact, oftentimes when your customer needs a bond, they also need a proof of insurance, a proof of liability insurance. However, they do in fact have very specific differences, and in this next section, we will cover those differences. We're going to discuss the parties involved in surety versus the parties involved in insurance. We'll look at how each industry looks at losses, and then that will lead us into a discussion on how premiums are calculated. And finally, we will identify the risks involved with surety versus insurance. So the first difference is that a surety bond is a three-party agreement. Back to our discussion earlier on surety bonds, there's the principal, who is the customer, the obligee, and the surety company. This differs in that insurance is a two-party agreement between a customer and an insurance provider. So what this means is the surety agrees to pay the obligee in the event of a default by the principal, and if that happens, the surety will look to recover any loss. On the other hand, the insurance company agrees to pay the insured in the event of a loss without the right of recovery from the insured. For example, the insurance company will pay the insured for a new roof on their house if it's damaged by hail. If they do that, they will not come back expecting payment from you. Unlike with surety, if a contractor were to make a mistake or something goes wrong, the obligee on the bond would make a claim against the surety company for payment for the damages, and then the surety will then look to the contractor to be paid back. The principal on the bond cannot make a claim against their bond, and it is not there to protect them. It is there to protect the obligee and other third parties. As you can see, these are some of the basic differences between surety and insurance. Not only is there the three-party versus two-party, the surety looks to recover their losses, which leads me to my next point. Losses are not expected by the surety company or with the surety. Each industry looks at losses differently. What I mean by that is the surety industry does not expect to have losses, or if losses do occur, that is why the state and federal governments require the bonds to be in place, because losses are going to happen. And we will see through further discussion about premiums and underwriting. The surety looks to minimize those losses because they underwrite with zero loss expectation. Surety premiums are not calculated based on expected losses, whereas insurance premiums are set based on anticipated loss ratios. Losses are expected and the rates are set year to year based on that loss experience. They plan their premiums off that historical data and anticipate the amount of premium needed to cover future losses. One of the reasons the surety company does not expect losses is because for a surety bond, the losses are recoverable. One of the key pieces of that recovery is the indemnity agreement or application that a principal signs when purchasing a bond. We'll cover more about the indemnity agreement a bit later. But what it means is that if there's a claim on the bond, the surety will pay the claim, but then they will look to the principal to repay that claim obligation. However, with insurance, there will be a claim, and the insurance company will pay without the expectation of reimbursement. As stated before, a good example would be if a homeowner files a claim for hail damage to the roof. The insurance company inspects the roof and agrees to the damage that they would pay out on that claim and not expect the homeowner to pay it back. They may, however, adjust future premiums for new policies if they suspect hail damage and roof replacements will be a continuing occurrence in that area. Continuing on with the difference in premiums is the surety company set their premium to cover expenses, not losses. Insurance premium, again, is set on loss, life expectancy, and expense. Lastly, surety companies, since they are not expecting losses, they are more selective on their risks and look to write only good credit risks. Insurance companies, however, look to take on more clients to maximize premiums to help cover their expected losses. The law of large numbers: take on as many clients as you can, knowing that the good risks will ultimately outweigh the bad risks, and you'll still maintain a profit. So if a insurance company still underwrites, but since they look for larger number of clients and premiums and are anticipating a certain amount of losses, they can be less selective with respect to the risk involved. So there you have it. As described, it's clear that although surety is technically a form of insurance and serves a very specific need and has very specific characteristics. Some of these are sureties, a three-party agreement between a principal and a surety and an obligee, and insurance is a two-party agreement. Bonds are to protect the obligee, or in some cases the consumer, but not the principal. Insurance is there for the protection of the insured. Surety expects to be paid back for any claims they must pay on, unlike insurance, who make their payments to the insured and do not expect to be paid back. Sureties do not expect losses. Insurance companies expect losses and calculate their premiums around them. Now we'll get into our next section of the presentation of contract versus commercial surety. Now that we have a basic understanding of the definition of surety and how it differs from insurance, we're going to talk about some of the different types of surety bonds. Typically, we will discuss the difference between a contract surety bond and a commercial surety bond, and then we'll get into the specific types of commercial bonds. When we talk about contract surety bonds, it is important to note that most surety companies separate bonds into two categories: contract and commercial. The reason they do that is because they have some fundamental differences. Primarily, the difference is a contract bond guarantees a specific contract and the obligee is the project owner. For example, let's say your city is looking to put in a new road, but to do that, they're going to have to hire a contractor. With all that comes the aspects of completing the project, including the cost, time, materials needed to complete a project. Within the contract surety world, this is referred to as a payment and performance bond. They're going to want to guarantee that the contract is completed according to the specifications laid out in the contract. And they will want to guarantee that all the suppliers and subcontractors are paid as well. Once these guarantees are met, then the surety's obligation on the bond is complete. So it's guaranteeing that with just one specific contract, and if the contractor were to default on the contract, then the surety company would compensate the obligee financially for any losses. Additionally, the surety may even help find another contractor to complete the project. Now, on the commercial side, it's a much broader range of obligations, guarantees, and obligee. It really covers all other bond types that are not contracts. These are bonds that could be required by federal, state, or local governments, or even private entities. They were there required to the various statutes, regulations, or specific requirements. Some examples include license and permit bonds, fiduciary, probate court bonds, and other types of bonds. As you can see, and we're going to show you, there are many different types of commercial bonds. I'm going to touch on these different types, but it will be a very high-level overview. A deep dive and get into all the different types and specifications of each bond, underwriting requirements, and premiums would take all of our time today. The first part we're going to look at is license and permit bonds. These are the majority of the commercial bonds that we'll see on the commercial side. These are bonds that are required to be licensed in a regulated area. This can be a contractor looking to be licensed as an electrician or a plumber. Part of that licensing by the city would be to post a bond. Now, this wouldn't be for a specific job or contract. It's more of a guarantee that while working on any project within that city, they will follow the rules and obligations and guidelines that the city has set in place for contractors and those working with the public. Fiduciary and probate bonds are bonds that protect an estate. Maybe a loved one passed away and their assets need to be distributed to their heirs. So you post a probate bond to appoint someone that would take on the responsibility of distributing assets of the estate. Another example of a fiduciary bond would be the care of a minor or an incapacitated ward. This could be a child under the age of 18 or a senior citizen that is incapable of taking care of themselves. Bond guarantees that a fiduciary will use funds in a responsible manner, pay for the appropriate care of the ward. Then we have other types of court bonds. These are bonds that guarantee a party will abide by a court order. An example would be a replevin bond. Let's say a bank gives a loan for a car and the owner defaults on that loan. Before they can repossess the car, the court will require the replevin bond to guarantee that they have the proper paperwork and are in fact entitled to take the property back due to the default. Public official bonds. These guarantee the honest or faithful performance of elected officials. An example would be a city treasurer's or city manager's bond. The bond guarantees that they do things correctly and that they don't steal funds or do something fraudulent. Fidelity bonds. These are bonds that protect employers from dishonest acts of employees. Say an employee goes into this business and they steal some valuable equipment. The bond guarantees that the company is protected despite the actions of a bad employee. We also offer what are known as non-construction performance bonds, or NCP for short. These bonds guarantee the performance of a contract. However, they are different than standard contract performance bonds. These would apply more to supply or service contracts. Subcontractors would be the best example of people that need to provide these types of bonds. And then there's miscellaneous bonds. This is a wide variety of different obligations. One example includes a utility deposit bond. Many utility companies require this bond for any service for a business. If the business is unable to pay for the utility service, then the bond would protect the utility. As you can see, this is a very broad range of commercial bonds. When I started with merchants, I knew very little about it and had only ever really heard of a contractor type of bond. I was unaware of some of these bond categories, such as court or fidelity bonds. And as I've continued to learn more about the surety industry, I can see it's clear why these bonds are needed and what protections they offer. Now that we have some framework of what surety is and different types of bonds, I want to talk about the actual bond form. So on this slide, you'll see a basic generic bond form. Each surety company will have a variation of this, but not all bonds use this generic form. Some obligees, in fact, have their own bond form. In fact, there are thousands of different bond forms that are being used. Merchants has over 6,000 forms in our bond library. However, with that said, all bond forms do follow the same basic outline. They will all have an insurance clause, which is the reason for the bond, a guarantee, and other provisions. Let's take a look at our generic bond form. This will be used whenever an obligee requires a license and a permanent bond, but does not have their own bond form. There will be an insurance clause. This will include the parties to the bond, which is the principal, obligee, and the surety company that are being used. It will also include the bond amount. Some bonds have a fixed amount, like the permanent bonds, and some bonds will have an amount dictated based on circumstances. Court and probate bonds are good examples of that. This section will explain why the bond is needed. On generic bond forms, this may be open-ended to be completed by the agent. In obligee-specific forms, this would include the municipality statute or associated law as to why they want the bond. It would give us a frame of reference if we wanted to research why that municipality requires the bond. And we have a guarantee section. This lists what the obligee must do to comply with the terms of the bond, or what the conditions of the obligee may claim. Finally, there's the other provisions. This would include a number of items such as the cancellation clause or cumulative liability wording. There are numerous items that go here and that could affect if we would want to write the bond. Megan will go over this a little later during her part of the presentation. Now, let's take a look at an obligee-specific form. This form is from New Mexico, and it has the insurance clause, which shows us that the obligee is the state of New Mexico. And there was a spot for the principal. And in this example, Merchants is listed as the surety. You can see that the bond amount is fixed at $10,000 as the reason and the guarantee with references to New Mexico law on why the bond is required. Finally, it looks like some other provisions, such as a 30-day cancellation clause and an aggregate liability clause. Finally, I'd like to talk about electronic bond forms. And what I mean by that is there are a few obligees that don't require a hard copy bond form because they expect the agent or surety to provide a bond form electronically. In these instances, you would still gather the appropriate documentation from the principal. However, instead of ordering the bond on the surety website and providing a completed bond form to the principal, you actually order the bond on the obligee's website. It's nice because it makes more of a streamlined transaction in most states. Although there's not a hard copy of the bond form, you can still see pertinent information, such as what the bond is guaranteeing and the reasons for the bond on the obligee's website. But as you can see, although there are thousands of different forms, they will all follow this basic outline. And this will help you when you get requests for different types of bonds that maybe you haven't had requests for in the past. And it will help you decipher why the bond is needed, and then also help you have an understanding of what may be needed for underwriting. Now, let's talk about renewals. Now that we've got some background on the bond form, we can get a little bit more into this. There are three ways a bond can renew. And of course, there's the option that bonds don't renew. Renewals are determined by the type of the bond form language or the statutes. This would typically be the wording in the bond form we previously discussed, and it will be under the other provisions section toward the bottom of the bond. So, as we mentioned, some bonds do not renew. It runs for a specific term. An example would be a lost title bond. Many states require it if a title is lost or destroyed, and they need a bond before the title is replaced or a new title is issued. A bond is required for a certain amount of time. In this example, that it would be 3 years. After the 3 years, the liability by the insurance company is completed, and we would set the bond to non-renew. Most bonds, however, will renew, and more often than not, they would be continuous. This is the most common bond type of renewal. This assumes that the bond will be enforced until it is canceled by the surety, principal, or the obligee. Once the bond is presented to the obligee, they assume that unless they hear otherwise, the bond is still active and enforceable. The surety company may review the bond on an annual basis to ensure the principal still meets the underwriting requirements. An example of that would be if credit is an underwriting factor, they may pull a new credit report at renewal, and if it is still satisfactory, then they'll renew the bond internally. They'll collect the premium for another year, and the bond stays in place. On the bond is continuous, we'll look at this, look to be sure there's a cancellation clause, which will allow the surety to send cancellation on the bond and their liability. The example then again would be if the credit is no longer satisfactory. So we could send that cancellation notice to the obligee and be released from our liability. Some bonds could renew with the renewal bond. This will require the entire new bond form to be sent to the obligee with updated forms. The original may be effective from June 1st, 2024 to June 1st of 2025. At the end of that term, the obligee may want a new bond form to confirm the bond is still active with the surety company. The surety company would prepare the renewal by the same bond member with an updated term of June 1st, 2024 to June 1st of 2025. We do not need to look at this differently, as it may imply additional liability. Since the obligee may be under the impression that each bond they receive is a full new obligation. So how we determine that is typically on the other provisions section. It will identify if the liability is cumulative. If it is, the surety will take the time to review the underwriting to make sure that the principal still qualifies. Example of that would be if a bond is, say, $10,000 and it is renewed 3 times and the bond has cumulative liability, our obligation is now $30,000, and if the principal may not qualify for that higher amount, the liability is not cumulative, then the penalty remains at $10,000, regardless of the number of years it's been renewed. And then last way a bond renews is with a continuation certificate, which will oftentimes be referred to as CC. This is similar to a renewal bond. This is used when a bond form specifically states the time period the bond is in effect for. The June 1st of 24 to June 1st of 25. CC basically updates the term to make sure the bond renew effective for the new term. These are a little easier to renew because the bonds that renew with a CC typically have aggregate liability language. And what that states is no matter how many times the bond renews, our liability stays in the stated amount of the original bond. And during the anatomy of the bond form section I mentioned, there are electronic bonds. These will also renew, and typically the bond form language indicates it's a continuous bond. However, the obligee may still require some input into their system at renewal to confirm that the bond stays active. You could almost consider that like an electronic continuation certificate. So that wraps up the different ways that a bond can renew. And although each has its own renewal requirements as the agent and surety, that's a good time to review the bond. The surety company can review to make sure that the risk is still appropriate and that they are okay to continue. The agent can use this as an opportunity to check with their client to make sure that the bond is still needed and perhaps that they have other services or other bond needs. And finally, it alerts the principal to review if they even still need the bond. Maybe the electrical contractor no longer works in that particular city, so they won't need the bond to renew. Okay, so with that, we've covered very basics, the definition of a bond, how surety differs from insurance and different types of bonds, and what a bond form looks like and how it renews. Now that we've got you all pumped up and ready to start issuing bonds, we're going to walk you through those steps. Our ultimate goal of this course is for you to visualize the bond process as a whole and to describe it as an everyday bond life cycle. To accomplish this, I'm going to go over the anatomy of a bond application and how that applies. We'll go over various types of organizations that we receive indemnity from. We'll go over corporate resolutions and how these come into play. I'll touch on specific bond questions from our second page of our application. Just as a heads up, we will take a 10-minute break after my presentation of my portion of the presentation, and then Megan will take over from there. I want to start off with a story to really set the tone and explain these initial stages of the bond life cycle and why it's important to visualize this. When I finished my trading, I was on the underwriting floor. I took a phone call from an agent. Her name was Anita. She called in and we were both a little overwhelmed at first. Me being an inexperienced and not really understanding what she was asking, and her for hearing a bond type she never heard before. She called in and said, hey, we have a request for a $100,000 bond request. So I just started rifling off questions at her, and you could tell she was getting overwhelmed on the phone, and I could tell it may have been a bit too much asking for or a simple $100,000 bond request. The best way I could have avoided the situation and helped bring all this information together was to visualize this life cycle of the bond and help Anita visualize that as well. I want to use this story today to help supplement the topics that we're going to cover. Let's start off with what I should have done differently in the Anita situation. When she called in, I should have been upfront with her and asked her to get a bond application signed and completed so we can drill down on what type of bond her client was asking for. That's really the first place to start here, and that will bring us to our first point. Why is the bond application so important in the commercial bond process? You can see an example of our bond application here on the screen, and it really provides underwriters and the surety company the basic information to determine the course of action for the bond, the underwriting, and ultimately the issuance. As the surety, Merchants Bonding has three main objectives for this bond application. We want to determine the type of the bond, the amount with the two pieces of information, and a lot of times we can drill down on exactly what bond that is. Or even if we just get principal analogy, those are another two important pieces of information as well. Filling out this top blue section there as much as possible and as accurately as possible can help your underwriter deduce what bond is truly being required. If Megan were to receive a request from ABC Trucking Company for what was written as a $75,000 freight bond, with only that information, Megan could pretty quickly be able to determine that, all right, this is probably the federally required $75,000 ICC broker bond, the BMC 84 bond. The other main objective is the indemnity agreement, and that we're trying to find and agree to, and that's what's there in the red. I'm going to get into that in more depth there in just a second. But I do want to stress that this bond application is the catalyst for the bond life cycle. It really starts the whole process. It helps the underwriters determine, well, what the bond is required and who's requiring it. When will it need to be enforced? Where is the overall risk taking place and why ultimately is it needed in the first place? Helps make the process a lot easier to have this filled out from the get-go. And now let's get into the indemnity agreement and explain why this is also important and what it constitutes here. Let's go back to the Anita story and let's pretend she got all the information filled out on this bond application, but now she's questioning the indemnity agreement of that application. Fine print scares a lot of people, and it's important as an underwriter and as an agent to truly know and explain what the principal is signing on the indemnity agreement for the commercial bond application. Let's take a step back and really define what indemnity is and what the indemnity agreement is. When someone indemnifies or signs the application, they're signing an agreement between the principal and surety, and they agree to several basic guarantees in the agreement. I want to point out that our indemnity agreement is very similar to other sureties. It may differ in a couple ways, but ultimately, a lot of sureties out there are trying to accomplish these same goals with indemnity over in the language. Like I mentioned, there are several basic guarantees in the indemnity agreement. Let's go through them so we can picture of what it entails so it's not so scary up front. The first basic guarantee is that the principal attests that all the information is correct. That is a standard fraud clause. We want to make sure that we're receiving appropriate and truthful information for the request so we can underwrite appropriately. Next is the principal agreed to hold the surety harmless. And this really goes back to the true difference between surety and insurance that we touched on earlier. Indemnity is a contractual obligation of one party to compensate the loss incurred to the other party through the act of the indemnitor or the act of any other party. What we're trying to accomplish with this is that in the event of a claim, we, Merchants Bonding Company, would be held harmless. Next is the principal agrees to post collateral if requested when reserve is posted. What this means is our claims examiners came in and mentioned to us that the claims process for a specific claim might be drawn out and it could take a while, but we want to ensure that if we do pay out, that merchants will be repaid. We may have to go back to the principal and ask them to post collateral until the claims process is resolved. In the event we have to pay out, we will just have to collect on that. That's the worst case scenario, but that is why we have it in there. Just so that the principal know that in the event it's happening, it is the one here in the indemnity agreement. Next is the security agreement and the lien on property in the event of a claim situation or trying to resolve a payment. Maybe merchants isn't receiving a full payment on something, or an applicant isn't cooperating to post collateral as mentioned in the last clause. We would take this bond application down to the courthouse so we could put a lien on a piece of property owned by the principal. For example, we could put a lien on a second home down in Florida that's on the free and clear. Or we could put a lien on the primary residency as well if needed. Again, this is a worst case scenario. We don't want to go that route, but it's one tool that we have in our tool belt to facilitate that repayment in the event of a claim situation. The basic guarantee is that the indemnity applies to any changes throughout the bond life cycle. The best example I could give is a probate situation. With a probate bond, you may have the bond amount increasing or decreasing through the life of the bond. We don't want to go back to you, the agent, and say the principal needs to sign a new application because the bond amount changed from $100,000 to $110,000. This is one indemnity agreement that applies to all changes throughout the bond, and that's why we have that stipulation in there. So it's easier and more efficient on everyone throughout the process. Lastly, one basic guarantee in our indemnity agreement is that we can run credit at any time on the principal. A lot of risks out there are currently credit-driven, and underwriting is just that personal credit report, and that is an important piece of information that we receive permission from the principal to run their credit at any time throughout the bond process. Continuing on the indemnity agreements, that bottom section there, you may have noticed, below all the verbiage, is where we have a bunch of signature lines. We're going to take a little bit of time to explain those and to clarify what we're trying to capture. You might see a witness signature. For some risks, we require that principal signature is witnessed. Again, that depends on the type of risk and may depend on the underwriter's discretion. So that's why we have those there. It also requires spousal indemnity or on certain bond types of risks and may require those signatures to be witnessed as well. We have, as we stated, we have multiple signature lines there to accommodate different situations with different types of signatures we may need. Capture indemnity is important. We want to make sure it's handled correctly the first time around so we don't have to send the application back and forth a million times to sign correctly. So let's get into what exactly is expected for someone signs our application in different scenarios. Going back to the Anita situation. Anita is now comfortable with the indemnity agreement, but now she brings up a good question. If her client is a sole proprietor, how would they sign our application properly? We'll talk about the different types of entities and how this on our application. I want to stress that every situation is different, but many different combinations of signatures depending on the risks of the business structure. Keep that in mind while we're going through this. Let's pretend that Anita's client owned a food truck business. He goes down during lunchtime selling food out of his truck. Right now, his client is a sole proprietor. He owns a single trunk and he's predominantly the one running the business. How would a sole proprietor sign our application if they needed a bond? What we would need for the sole proprietor to sign our application is on the first line capturing business indemnity, as well as the second line down below personal indemnity because he is the sole owner of the company. So there'd be two signatures. The applicant's signature would be in the name of the business because that's the name that the bond will be in. And then the owner will sign the second time down below on the indemnity line, as you can see on the screen there. Let's say business is picking up. This client goes out and one of his friends wants to become a partner because they want to do several trucks and get rolling throughout the town. Well, how would a partnership sign our application? What we need to capture indemnity from the partnership is we would need the partner, one partner, to sign on behalf of the business. Again, they need to sign on the applicant's signature line. Then we would need each partner to sign personally down below on the indemnity lines. And on the risk, again, we may require spousal indemnity as well as witnessing truth. So there could be different combinations for the partnership. But the important part here for the partnership that one partner signs on behalf of the business to cash for the business indemnity. We also need personal indemnity of both partners. They have 50-50, one can sign, and it doesn't matter a ton. While if there's a majority owner, ideally the majority owner would be the one signing on behalf of the business, if it were, say, a 75-25 split. Now let's say these guys are booming and they have brick and mortar stores throughout the country and they turn into a corporation. How does a corporation sign our application? What we would need is for an officer of the corporation to sign on behalf of the business, and you guessed it, on the applicant's signature line there as well. We want to ensure that they have the capacity to sign on behalf of the business as well. We also need each stockholder, majority owner, and potentially spousal to sign personally. Again, every situation is a little different, so this could vary, but that's how you would go about capturing indemnity, firm, and LLC. And let's back up for a second. The LLC is comprised of members, technically owners of the business, and the proper indemnity. We would have the managing member on behalf of the business, and then the other members to sign personally. Let's say these guys get some advice from an attorney, and they want to become a corporation. How would a corporation sign our application? Similar to an LLC, we would have an officer of the corporation sign on behalf of the business. I'm sure they have the capacity to sign as well. And then we would need the stockholder, the majority owner, and potentially a spousals to sign personally. Again, every situation is a little different. So that's how we capture indemnity for a corporation. Kind of catching the theme here on how this is going to the owner or somebody authorized to sign on behalf of the business. sign the applicant's signature line, owners and spouse will sign down below. We'll get into the corporate resolution a little bit later and how that ties into this. So that's a basic example of indemnity and how a corporation would sign. Now we're going to get into the second page of our application. The sections we have listed on the back here of what type of bond information we are going to need. Some bond types are going to require that the surety company to receive additional information, and this is really to qualify a certain type of risk. Coming from an underwriter, this is information that is essential and really helps us determine the proper rate and risk analysis. Megan is going to get into rating and information that we need a little bit later. But these are the basic examples of common information we see a lot out of and might require higher. These questions help expedite the underwriting process and help gather some additional information. So on the top section of page 2, starting with license and permit section. License and permit have a broad range of bond types and guarantees. Very basic information that applies to a lot of Class 1 or Class 2 types of bonds. We'll explain and get into types of classes a little bit later and how that ties into the process as well. But what you need to know is that these are very basic and easy bonds to process, hence why there's not a ton of questions on the second page for license and permits. Now, as you can see, the probate section there underneath actually has more questions. This section is incredibly important to have for probate business. The information is filled out in this section because of how we want to qualify the risk. A lot of information requested here is more important than, say, the credit report-based type of risk. There are a lot of variables and moving pieces with probate, and it's very situational. What we're really trying to understand here is if there's an attorney involved, and are they going to remain involved throughout the process? We want to know the applicant's relationship to the ward or the deceased, depending on the situation. We're going to want to know if there's heirs to the estate and if there are any disputes amongst the heirs. These are all pivotal in our underwriting process and can determine if we're going to approve the risk or if we need to request more information. Because of these moving pieces, we really want to be able to gather what's all going on in the situation for probate. This also holds true for fiduciary and public official bonds, as you can see on these sections here on the screen. Before the information goes, it again is essential to the underwriting process. Questions in these sections relate to who a plaintiff is and who a defendant is, who is the attorney, what court will be the obligee. A lot of situational information will come from the court documents, which should be provided with this applicant for fiduciary, courts, and probate bonds. As for public official, you may want to know that if they were elected or appointed, and then their term of office that goes with that. This helps us know how long we're going to be on the bond, if the premium is going to be paid for the term, or if they're going to be paid annually. We may want to know some auditing information about the public official and the process there, whether there's counter signatures, checks, and other questions you listed in the boxes. This helps us determine the situation and if we're going to require more underwriting information or potentially just approve the bond filled out because of the risks and the internal controls that are answered here on the client. Next, you're going to see several other bond types that require just more basic information. One section here are lost securities. This is an interesting one too, because we'll receive a submission and someone will say, hey, we lost a $10,000 check and our bankers are requiring us to post a lost securities bond. Well, we are going to ask a few questions. We're going to ensure that how long has the check been lost? Kind of strange that someone just misplaces a $10,000 check, but we would want to make sure that the situation makes sense to us. If they lost it yesterday, we would want to make sure that they're going to take some time to go through their due diligence and make sure they check that the check wasn't just misplaced or someone filed it incorrectly. We're going to ask the types of questions for loss security. And this is, again, essential for our underwriting process, and best that we get it all up front. It's the same for certificate of title bonds. We're going to want to know the make and the model, the vehicle VIN number, and the year of the vehicle are important to receive all that information accurately and ideally up front as well, because this information is often be translated to the actual bond form. So, as I've stated, it's important to receive all this information up front so we can streamline this process as much as possible. It really helps underwriters because we can respond very quickly with quality information because the application was filled out properly. We want to get back to you with quick and prompt underwriting decisions just as swiftly as you want us to get an answer. Second page helps streamline that process for the bond type standpoint, and we want to be able to service your needs just as much as you're trying to service your client's needs. Then there's a third piece of our application that we don't have on the screen. Other sureties include this as well, and it's a blank financial statement. Typically, the blank financial statement can be used as a personal financial statement, business financial, or it could be combined. Ideally, when taking a financial statement for an underwriting process, we prefer that a CPA prepared statement is available, but we understand that those can be expensive and a time-consuming process, and sometimes, depending on the risk, we are willing to accept a handwritten statement if necessary and if nothing else is prepared. Ideally, the handwritten statement would be used on our app is for personal financial statements because not everybody has a personal financial statement prepared and ready to go at any given time. While the business statement is typically more prepared by the CPA, either compiled or audited, ideally audited. So that is one thing that I did want to mention as well, that the third page of the app does include a financial statement, and other sureties require that as well. So we've covered what a bond application looks like, what the indemnity agreement consists of, and how different entities signed the indemnity agreements.
Welcome back from our break. My name is Megan Menier, and I will take you through this second portion of this training. We are going to go through the following in this section: the indemnity agreement, collateral, power of attorney, letter of authority, bond reporting methods, rates, factors affecting rates, levels of underwriting, and finally, bond opportunities. So, Nick has covered several items, starting with the definition of surety and how that differs from insurance, all the way to the anatomy of a bond and bond application. Let's build on that, and now I want to get into our general indemnity agreement, otherwise known as a GIA. So let's go back to Anita's client and give an example for when a GIA might be used in this situation. So Anita comes back and says, our client has 15 food trucks, and each one needs a separate bond because the state is requiring them to get these. But he doesn't want to fill out and sign an application for each of these 15 bonds. Having a need for multiple bonds is the most common reason to use a GIA on the commercial side, and this is really out of convenience. The other reasons to use a GIA is when a principal has a large bond need or a complex organizational structure, and we feel the GIA is a little more encompassing as opposed to our short form indemnity agreement. The GIA captures all those basic guarantees on a commercial bond application that we previously discussed, but it does have some more detailed language. Our GIA has a total of 18 different clauses. Several clauses help explain how the GIA is not an automatic qualifying mechanism, and the surety reserves the right to qualify every individual bond request. Basically, what that means is, by signing the general indemnity agreement, it does not give our principal unlimited surety credit. So, it's important to stress that even though they're signing this indemnity agreement because of the multiple bond needs, it doesn't automatically qualify them for the next bond. An interesting clause in our general indemnity agreement provides the surety the ability to inject cash or loan money to the principal to help facilitate an ongoing business and avoid a potential claim. This is one section that differentiates the GIA from the commercial bond application. The best example I can give for this is a contractor who might be 90% complete with their project, but they are in a place where they don't have as much cash flow as they anticipated. They just need to complete this project, and they want to get rid of the bonds associated with the job to avoid a claim situation. So then, if the surety deems the situation necessary to inject some cash, we do have the ability to do that for the contractor to help them complete the project. The principal still has to pay the cash back. This isn't free money being handed out, but if we deem it beneficial as opposed to going through the claims process, we're definitely going to do that. And we have the ability as outlined in the general indemnity agreement. Another difference is if the co-surety or reinsurer is needed to write the bond, this agreement states that this shall be to the benefit of the reinsurer or co-surety as it would apply to merchants. It makes sense that if another party is needed to write the bond, maybe to fulfill the obligee requirement, our GIA would translate to the additional insurer as well. There is also language to be removed as an indemnitor from the agreement. This is another benefit to the principal, that if they sell the company or the family business gets passed along to their children, they could be removed from future liability. Then, the last main difference, and I'd like to stress this, is that our GIA must be notarized to be accepted, and we usually want an original copy. Nick mentioned a corporate resolution in the first portion of this class, so let's move on to that. So when is a corporate resolution required, and what is a corporate resolution exactly? The best example I have is, let's say I went down to the bank and I wanted to take out a $100,000 loan on behalf of Merchants Bonding Company. The bank underwriter is going to come back to me and ask, hey Megan, why do you as an underwriter have the ability to take out this loan and sign on behalf of Merchants Bonding Company? You will need to show me some proof that you have the authority to do this. It would be common to ask for that type of authorization. That is what we are trying to do with this corporate resolution. We want to ensure that we are getting the correct person in the corporation signing our indemnity agreement and that they have the capacity to sign on behalf of the company. So let's go back to Anita's example with this as well. When a company expands very quickly, like Anita's client did, new positions are created every day. And again, we want to ensure that we are getting the proper indemnity. We might require this corporate resolution to show it's not a manager of one of the restaurants or a driver of one of the food trucks in Anita's client example, but signing our indemnity agreement on behalf of the entire company. So what a corporate resolution is proof that an individual of that company has the capacity to sign. In some cases, we may require a board resolution, as shown here on the screen, that authorizes a corporate officer to sign on behalf of the company. Or it could just be a letter from the corporate counsel communicating this person does have the capacity to sign the indemnity agreement. We also have had companies send us their corporate bylaws, which have also outlined which people do have the capacity to sign on behalf of the corporation. You will see this required when there is a complex organizational structure involved, or even potentially a nonprofit. A larger school might be an example of when we would ask for this. Let's get into the next topic, which is collateral. What is collateral anyways? Let's look at a basic example and say the alternator went out on my car. I take my car to the shop. The mechanic would call me and say, hey, we figured it out, your alternator is bad, we can fix it up for you. give us authorization, then I would say, all right, go ahead, fix it. I really need my car. So they would fix my car, call me, say, hey, it's done, Megan. You can come pick it up. Well, in this instance, the repair shop is using my car as collateral in case I don't pay for their services. Basically saying if I don't pick up my car, they can put a mechanic's lien on it. This would be their leverage to get me to pay my bill. So, pretty classic example of collateral there. What do you need in a collateral situation? The collateral is usually required upfront after the application and qualification process before the bond is issued, and is usually in the form of cash or an irrevocable letter of credit or ILOC. Collateral can be used when an applicant is close to qualifying for a certain type of risk, or if the bond poses an increased risk that requires additional security no matter who the applicant is. Sometimes collateral may be required midterm due to the situation or risk changing. Collateral does not qualify a non-qualifying risk. Merchants typically does not take collateral, but we do have certain types of bonds we write and require collateral. If there's a potential for collateral to be required, your underwriter will mention this at the beginning of the underwriting process. We are very transparent if collateral is going to be needed. After giving an approval, the collateral is required. A prime example of this would be merchants would require 100% collateral on a release of lien bond. This type of bond is required for a contractor who may need to bond around a lien that was filed against one of their projects. This type of bond is riskier, and that is why we would require collateral in that instance because of the risky nature of the bond guarantee. Claims come in on it pretty frequently, and we will get more into that in just a second here. Again, this underwriting and collateral process will generally happen before the bond is issued. And I want to stress this again, that collateral does not qualify a non-qualifying risk. Just because the client is willing to post collateral does not mean they then qualify for that bond. So, how exactly would a principal post collateral? One type of collateral in the surety world is real estate. The contract department may be more open to taking real estate as collateral, but as for the commercial side, we do not take real estate as collateral because it is expensive and very time consuming. It doesn't make sense for smaller commercial bonds and the premium that's received to go through this process and the paperwork to file the collateral on real estate. It may be different at other sureties. So please keep that in mind that this is a merchant's opinion and not the surety industry as a whole. One form of collateral we do take on the commercial side is cash. Makes sense, everyone is willing to hold cash. When cash is taken, we will have the principal sign a collateral trust agreement or a CTA. The CTA is an agreement for the surety to take cash, and it outlines the rules for holding, investing, and ultimately returning the collateral. Merchants will actually invest the cash posted in an interest-bearing account. The principal will accrue interest while we hold their cash. Merchants will release the cash with interest earned when merchants is exonerated from the risk. It's important to know that merchants need it to be completely released of all liability for collateral to be returned. This will include any liability tail on the bond. Next, you might see an irrevocable letter of credit. This is also known as an ILOC, and that is also an acceptable form of collateral on the commercial side. So, what is an ILOC? ILOC is a financial instrument used by banks to guarantee the principal's obligations to a surety. You can see an example of the agreement here on the screen. We will only accept this agreement on our form. The wording cannot be modified unless all parties agree. Now, you might see different different amounts of collateral being required for different sureties. You may see other sureties with 50% collateral or even 150% collateral, and these percentages are in reference to the bond amount. Generally, merchants requires 100% collateral on certain types of risk. Typically, we don't go above or below that. There may be times where losses incurred are more than a stated bond amount, and the surety wants to make sure that those excess losses are covered by collateral. And that's typically when you will see the more than 100% amount. Like if a court bond that contains language that allows attorney's fees and court costs to be claimed in excess of the bond amount, this would be an example of when a surety would want more than 100%. The surety may require less than 100% if the bond amount to limit the overall exposure to certain types of risk. There may be a probate example out there where you will see collateral is only required for the liquid assets of the estate, but the surety is not too worried about the rest of the assets, such as the real estate. But that's a basic example. You don't see that terribly often, so that is a high overview of collateral. It can definitely get more intricate, but it's a good starting point and gives us an idea of what collateral is, what instruments can be used as collateral, and when they would be used. Now, to summarize things again, let's recap the initial stages of the bond life cycle, and hopefully visualizing this cycle with our examples will help glue together all the information that we went over. Originally, we started off with the bond application and what information we need. We went over the indemnity agreement and what is outlined and covered in that document. We discussed the different entity types and proper indemnity. Then we touched on bond-specific questions on the second page of our application and how important that is. And we also went over basic collateral situations. These are things you will likely come across on a daily basis, and now we have a solid understanding of how that process works. Now, we will talk about the final stages in a bond life cycle to complete the loop. I'm going to start with power of attorney and how that ties into surety bonds. Then, talk about the letter of authority and how that relates back to the power of attorney. We'll go over the different bond reporting methods out there, the rates and factors that can affect them. We will explain our different levels of underwriting, and then finally, we will go over how to find some bond opportunities. So first, we have the power of attorney, or POA for short. Some of you may be familiar with this term, or maybe you've heard it used in another context. We will briefly go over the term in general and discuss how it applies to surety. We will look at an example to see how it works. So, the definition of POA is the authority to act for another person in specified legal or financial matters. And that authority can range from very specific to very broad. The person authorizing the other to act is called the principal, grantor, or donor. You probably won't hear this term very often, but in this case, it is merchants or the surety company. The person authorized to act is called the agent, or more commonly, power of attorney. And you can think of this as being very similar to binding authority for insurance, though the logistics are a little bit different. So, when bonds are executed, they must be signed by a representative of the surety company, and some surety staff are usually listed on the POA. But it's not feasible to use the surety staff exclusively. If our staff were used exclusively, the surety would need to issue and execute every single bond. So instead, agents are provided a POA to act on behalf of the surety within their authority or with explicit surety approval. I mentioned in the last slide how the authority can range. Well, in this case, the POA is very specific and only allows the attorney-in-fact to act on behalf of the surety for the purpose of executing bonds and anything related. The power of attorney must be provided to the obligee along with any issued bond. On the right here, you will see an example of merchant standard power of attorney. There will probably be a lot of similarities between ours and those you see of other companies. I won't read through the entire thing, it's not necessary, but what I will mention is that blank space towards the top, that's where the name of the power of attorney or attorney-in-fact will be listed. The rest is just the legal explanation of how it functions, which we already summarized earlier. Next, we will talk about letter of authority. This is given to agents to outline their authority and permits and restricts the use of the POA. It's usually based on bond type and amount. This allows agents to execute bonds without seeking surety approval, as long as that bond type and amount falls within the scope of the letter of authority. The caveat there is we still ask you to underwrite to surety requirements. So let's say you have something that falls within the scope of your letter of authority, but you have some additional information about that applicant, such as a history of bond claims, or maybe they are not doing well financially, or their credit is poor. We would ask you to decline that bond even though it falls within the scope of your authority. Here we can see a copy of Merchant's standard letter of authority. There will probably be some similarities between ours and those of other companies, but there will probably be some differences as well. We blew up one of the sections so you can see how that works and an example of what might be written in there. In the first column is the type of bond column, and it says license and permit bonds with a fixed term and cancellation clause. The next column over is the authority granted up to and including bond limits of, so we have $25,000 listed below that. So in this case, if you have a license or permit bond with a fixed term and or cancellation clause, and it's $25,000 or less, it's within the scope of your letter of authority. Then go check that final column, which is exclusions. You can see it says bonds where the state agency, federal agency, or trade union is the obligee. So even if you meet those first two column requirements, if one of those exclusions apply, it falls outside the letter of authority and would need surety approval before issuing. Now let's summarize those two items. Together, the power of attorney and letter of authority allow for the expedited execution of bonds and saves time on both ends. The underwriter is not bogged down with requests, and you, the agent, don't have to wait for approval on those bonds within the scope of that letter of authority. And some of you may be wondering, if agents are given POA to execute bonds, how does the surety know what's out there? Let's walk through the different types of reporting methods. First is pre-executed pads. Some of you probably haven't heard of this. It's an outdated method and it is not really used much anymore these days. These are pads of bonds already signed by the president of the surety company. The agent would take one of these pre-executed pads, fill in the blanks with the principal's name, dates, bond amount, and any other pertinent information, and then send a copy to the surety for billing and tracking. Kind of a cumbersome process, and as I mentioned, this is really not used much these days. It's not really that feasible. Now, most agents are given a POA instead, and there are much better methods out there for reporting bonds. Next, we have email, mail, or fax. Some agents may choose to use this bond reporting method and handle their bonds in-house for various reasons. The most common reason is that they have their own bond processing system and don't want to add steps to the process. An example would be that they use SurePath. So, what they do here is similar to the pre-executed pads. They take a bond form, they get bond numbers, fill in the principal name, and all the other information. Then they send over a copy to the surety for billing and tracking. Next, we have bordereau. This is a detailed memorandum, statement, or list of bonds. This is similar to email, mail, or fax methods where the agent still uses their own bonds, but they have such a huge volume of bond business that it doesn't make sense to send copies of hundreds or thousands of bonds at one time. One at a time. So instead, what they do is create a spreadsheet or some sort of report with all the bond information. Then they send that over to the surety company instead, and the surety company uploads that into their system. Finally, these days, the most common reporting method is a surety company website. Here at Merchants, ours is called the Hub. It houses a large library of specific and generic forms. Ours, for example, offers access to more than 6,000 bond forms in all 50 states. Merchants Commercial Department breaks the country down state by state, so underwriters are experts for their area. We have 30 underwriters currently handling all 50 states to make sure we have the most up-to-date information to make good underwriting decisions. We are each responsible to pull statutes and set up the forms in our website, the Hub. You also have the ability to save or favorite frequently used bonds so you don't have to dig for your most used bonds every time. The Hub uses programming to determine if an agent has authority, so you don't have to worry about exceeding your authority or issuing a bond maybe you shouldn't have. We also have come out with the Hub Express, which makes it even easier. The agent just sends a link for the bond to their customer. The customer fills out their information, pays, and prints off their own bond. Then Hub Express reports the bond to the surety and the agent. The Hub library has all the correct bond amounts, the appropriate term, and any other information you need to complete the bond form, so you don't have to worry about finding all of that stuff yourself. We also have a photo preview of the bond form to make sure you have the right form, and you can quote the premium for your customer. So everything is there for you on just one page. In case you are working on an order and are missing some information, there is the option to save an order and come back to it later. And then, best of all, when you do the bond, it automatically reports the bond to merchants. So all of those previous methods we've talked about are condensed and simplified into one place. Now we will talk about rates and what goes into that. Many sureties subscribe to the Surety and Fidelity Association of America, or SSAA rates. The SSAA file rates on behalf of member surety companies, and then those surety companies can file their own deviations as necessary. In order to determine the rate, we can get down to the real nitty-gritty with these. Rates start with the category, and those are, of course, your license and permit, court and fiduciary, public official, and miscellaneous fidelity. And then within each of those categories, you will then have a class. So we'll take, for example, license and permit. Within license and permit, the classes you may find include agriculture, contracting, finance and motor vehicle, etc. There are many of them. And then even further within each of those classes is a description. So we took license and permit, then let's take contracting. Within contracting, you will find descriptions such as general contractor, electrical contractor, roofing contractor, plumber, etc. Then finally, there's what we call a surety-specific descriptor. Here at Merchants, we use what we call a license plate. And the reason it's called that is because it is a 4 or 5 letter code and it kind of looks like a license plate. But that really helps you get down to a specific as a bond form to determine the rate. Rates are expressed as a percentage or per thousand. You may see this written as 1% or $10 per thousand. This is because many bonds are in increments of 1,000. So it's a very easy way to express the rate. Generally, a minimum premium does apply, and that's determined by the surety company. You'll often see $100 as minimum premium with some exceptions. So let's run through an example of how that works. Let's say you have a $10,000 bond and the rate is $5 per thousand. You do a little math there and you come up with $50. But it doesn't meet that $100 minimum premium. So in this case, instead of $50, this bond would have minimum premium of $100 to meet that minimum premium requirement. Now let's look at some factors that affect rates. We've mentioned before that sureties don't expect losses, but they do happen. And these are some of the ways that loss history could affect rates. First is the nature of the risk. Is it a compliance-only bond, which is a bond that guarantees you comply to a code or law? Or is it a financial guarantee bond that guarantees some sort of payment like taxes? A common bond you might see is a liquor tax bond, which guarantees payment of liquor taxes. Or we talked about the freight broker BMC 84 or ICC broker bond. This guarantees payment of shipping charges to the trucker. So in both cases, there's a financial component, right? If that obligee is not getting paid, they're going to care more than an obligee who wants that principal to follow the law. That makes the financial guarantee bond inherently more risky than one that is compliant only. Next, we have individual qualifications. A common one is credit score. That can be used either just simply to qualify someone for a bond, or there could be tiered ratings based on that credit score. An example would be the customer has a 700 credit score or higher. They get a preferred rate. Anyone else that does not meet that 700 score but still meets the surety requirements gets a standard rate. Some tiered rates can have other qualifiers and have more than 2 tiers. I personally have seen all the way up to 8 tiers. It really just depends on the bond. Another factor is experience. Is it a new business versus a business with multiple years of experience? The new business might not understand all of the requirements. They have some hiccups here and there. Maybe they get some claims because of it. Versus a company that has been there, done that. They have multiple years of experience. They understand the bond requirements and what goes into that. They are probably less likely to get claims. Next, we have a clause you may find on a bond called third-party liability. It's not that common, but what it does is guarantee recovery to any party that's damaged by the principal's violation of the applicable law. So you may see something on the bond form saying, bound unto village of ABC or any party damaged as a result. So not only can the obligee file claims against the bond, but anyone that thinks they were damaged as a result of that bond principal can also file a claim. And here you may see an increased likelihood for frivolous claims. That third party probably doesn't really get what entails a bond claim or a valid bond claim. So even if the claim is invalid, there are still costs associated with handling that claim, reviewing it, and ultimately maybe even denying it. So those types of bonds may have higher rates to factor that in. Another clause you may see on a bond form is forfeiture clause. Once again, this is not very common, but you could see it out there. What it does is it forces the surety to pay the entire penalty for the bond regardless of the claim amount. So let's say you have a $50,000 bond and you get a $5,000 claim, and that's not great, but at least it wasn't that whole $50,000. But if that bond form has a forfeiture clause, what's going to happen is the obligee is going to say, you know, you got this $5,000 claim, but we're going to have to ask you to pay the $50,000 and not just the $5,000. We will review everything and we'll give you back whatever we don't need. But of course, that doesn't happen. So in these situations, the surety looks at it as an all or nothing, and that makes it riskier. Earlier, we mentioned cancellation provisions that could factor into the rate as well. How many days notice are needed? Is it 30, 60, 90, or even 180 days? If you're reviewing that principal for renewal, for example, and their credit is shot now, maybe they're financially going downhill and starting to get some claims in, we want to get off that bond. The longer notice we have to give, that may increase the likelihood we get those claims or increase the likelihood of paying claims. What if the bond is not cancelable? If we can't cancel the bond, we're not getting off of that, regardless of how many claims come in or what their financial situation is. So those bonds are a little bit more risky. An example of a bond like that would not cancel would be court bonds. These bonds need a release from the obligee, which is the court in this situation. Right-of-ways are another type of bond that typically need a release from the obligee as well. And then finally, we have cumulative liability versus aggregate liability. Cumulative liability is where each bond term adds an additional liability to the surety. So again, let's take that $50,000 bond, for example, is written on January 1st of 2023. It then renewed for another term earlier this year on January 1st of 2024. What that new term did is it added an additional $50,000 in bond liability to the surety company. So for those 2 years, the surety could potentially pay out $100,000 in total claim liability versus just the $50,000. So you have this one bond for 10 years, for example. That is a potential of $500,000 in liability. An example of this kind of bond is the $50,000 Colorado motor vehicle dealer bond. That's one that has cumulative liability, and we have received a claim for $72,000. But what happened was some of those claims occurred at the end of 2023, and some of those claims occurred at the beginning of 2024. So instead of being capped at that $50,000, we were on the hook for that full $72,000 because our bond liability total was $100,000 for those 2 terms. That's opposed to bonds with aggregate liability, which are much more common. In terms of aggregate liability, the surety's liability is capped at the bond limit regardless of the number of years in force. So for that same bond, if we were on it for 10 years, instead of that $500,000 in total claim liability potential, that would be then capped at just $50,000. So you can see that makes quite a bit of difference in terms of liability for the surety and potential risk. Now I'll go over some of the things that go into underwriting bonds here at Merchants. We at Merchants have a class system. We have 6 classes. You may see some different or similar approaches with other surety companies. First, we have what we call Class 1. These are bonds that require no underwriting. They are instantly issued. You just go into the website, you type the information in, and it gets instantly issued. These are generally lower risk bonds, such as compliance type bonds that run to a local municipality or county. This also could be a contractor's license and permit bond for a village or town, or notary bonds are Class 1 as well. Next, we have Class 2. These are very similar to Class 1 in that there's really no underwriting, but we do require a completed and signed application. You can still go through the system website and issue the bond instantly, and then just follow up with an application. These are lower risk bonds, usually compliance type bonds. Maybe they run to a state or the federal government. So the reason for the higher class is possibly a higher claim volume on that type. We want that indemnity in place just in case so we can handle it properly. Class 3 is where we start getting into some of the underwriting. In Class 3, we require a signed application with the business and personal indemnity, and we run a credit report. We want a clean credit report, so these bonds could be slightly higher risk compliance bonds or maybe even a lower risk financial guarantee bond. We want to check that credit to make sure that applicant is on top of their obligations and will continue to do so with the bond. Class 4 is where we really get into needing underwriting. For this class, not only do we want that signed and completed application with business, personal, and spousal indemnity, we also want the credit report, and we need to review business and personal financial statements. These bonds are generally the pure financial guarantee type bonds, or maybe even large compliance bonds. We want those financials to prove that the principal can handle their bond obligations, but that they can pay us back in the event of a default. And finally, we have Class 5 and Class 6. We talked about collateral a little earlier. That's Class 5. As we mentioned, we at Merchants are not typically a collateral market, but we may write certain types of bonds if the applicant qualifies financially. We see this with defendant-type court bonds. Earlier, we mentioned release of lien bonds. That is a good example of a Class 5 bond. Another example is an appeal bond. These are bonds that guarantee to the plaintiff in a civil lawsuit that a defendant will pay any monetary judgment issued against them once they have exhausted their appeals. Chances of a successful appeal is estimated to only be 7 to 15%. So you can see here why those bonds would require collateral, because most likely they're going to lose and have to pay the judgment. And lastly, we have Class 6. These are bonds that we are not a market for. These are typically specialty type bonds that are hazardous for reasons such as reclamation bonds or even oil plugging bonds. And keep in mind, even though we at Merchants are not a market for these type of bonds, there are markets out there that specialize in them, and some even specialize in collateral type bonds as well. So please don't think you're out of luck if you come across this. And now that you all have a general understanding of commercial surety bonds, you're probably wondering, how do I get this business? Or how can I get more of it? The first place would be to look at those you already insure. They may have their own bonding requirements, or you can help find those that do. How many of you write insurance for restaurants? They may have requirements like liquor license bond if they serve alcohol. Contractors are another prime example. They often need to be bonded by municipality, county, or state government. There's attorneys as well. They probably don't have their own bond requirements, but they can help you find bond opportunities. For example, they probably have probate or other type court bonds. A lot of them, especially if they handle probate, sometimes they even sit in the courthouse looking for those opportunities. So you can network with them and try to get some of that as well. Another big one is you can use license types like license bonds or other bonds as a lead into other insurance types. Many agents have a so-called fear of surety bonds, whether it's due to lack of knowledge or understanding. So if you can become an expert or even familiar with them, it can help you stand out. I've heard stories from several agents where they were able to help somebody obtain bonding where maybe someone didn't want to or couldn't. It led them to writing other lines of insurance for them, such as property and casualty. And then there's online marketing. It's crazy how often I come across the agency's website and they don't mention bonding, and I know that they write it. That's a big and easy way you can get some bond opportunities. A lot of people, if they need bonds, they really don't understand them either. So they're going to Google surety bonds near me, and if you have that listed on your website, it will help you stand out and come up as a result in that search. Then this might turn into writing other lines of insurance for them. Nick, do you have any other ideas that can help everyone find some fun opportunities?
Yeah, definitely. One opportunity that has been utilized in my territory is staying ahead of legislation. License and permit bonds are required by law. So when certain bills are on the governor's desk about to be signed, the perfect time to start marketing for that type of bond and be available as a resource for those who need a bond. That legislation varies a bit. It could be bond amounts increasing. It could be new legislation requiring new bonds and stuff like that. Another opportunity is to go back to your surety underwriter and talk to them. Maybe your agency handles a certain niche of insurance. Go back to your underwriter and help set up a program and help corner the bond market. That's a good way to create a bond niche in a market you already have insurance for. What about you?
Yeah, checking with local municipalities, you can oftentimes get a list of licensed contractors. This could help establish a marketing or a mailing list. So not only would you be able to market surety bonds, but other insurance opportunities as well. And then in most states have a surety association. So by becoming a member, it will help with networking and gaining additional knowledge about the surety industry in your area. And then, in addition to those surety associations, there are also associations for specific types of business. A good example of this is most states have a motor vehicle dealer association. So you could join that association. And again, it's just for networking, and then possibly it could even get your name on their website as a provider of that necessary bond. So now that we've taken the time to understand an introduction to commercial surety, let's take a look at this in a real-life situation. Hopefully, at the end of the scene, you'll have a really nice understanding of how all the pieces we have discussed today fit together. So in this scenario, I'm going to be the contractor and Nick will be acting as the insurance agent. Hey, thanks for taking the time to meet with me today.
Hey Megan, good to see you again. I know we got your electrical license all sewn up last week, and I'm surprised to see you back in so quickly.
Yeah, so I took my registration down to the courthouse there, and they told me I need a $25,000 license and permit bond.
Gotcha. We can certainly help with that. Did they have to provide a bond form?
No, they did not. I did ask them what paperwork I needed, and they said to see my insurance agent and that they would have the bond form for me.
Understandable. All right, so I will hand you this application to have you start filling that out. And I just took this really great class with merchants, so I'm going to get logged onto their website, the hub, and see what we can do for you.
All right, great. So while I'm filling out this application here, I can see the top part of the application. It seems pretty self-explanatory, my name, my company name, what type of bond I need. I guess what I'm confused is, what's this indemnity agreement part in the middle of the application?
Perfect. I'm glad you've taken a look at that. That is a very important section there, and that really is the agreement between you and the surety company. It outlines a handful of different pieces there. I think I'll send a copy home with you so you can read it at a later time, but ultimately, if there happens to be a claim, that you end up paying the surety back. So this bond really isn't for you, it's for the obligee. The obligee could be the one making a claim against your bond. So in this instance, you're left with your electrical license. This bond would be protecting the city that you comply with the codes and everything that the bond is there for. And the city would be the one making the claim on the bond. There's a few other things in there that I mentioned. You can go home and read here. You can also run your credit report to qualify you for the bond and things of that nature.
Okay, and then on the bottom, it makes sense I would have to sign it, but I see multiple signature lines. Can you explain that a little bit more?
Great question. So the signature lines there are for multiple different types of entities. In the event we need to capture a few different types of indemnity. So I'm going to have you sign on this applicant signature line, which will be on behalf of your business since the bond is going to be in the name of your business. And I'll have you sign a second time down below on the indemnitor line. So you'll sign twice, and then I will witness as appropriate, and we'll get this going. So I found the bond form online. I'm pulling it up here. It does look like there's going to be $125 for the bond.
All right, great. $125. That seems pretty cheap to be bonded. So will I be bonded forever?
Another good question. So you will not be bonded forever. That is a 1-year price, and that coincides with your license. You can do a multi-year term from there, and that would be $219 for 2 years and $313 for 3 years. Pretty typical discount there for a prepayment on multiple years. Most sureties do that kind of thing, and then you'll all be set right.
And then once I take this bond down to the city, does it let me do work wherever I want?
It does not. So this bond in particular is to the city here. And if you went to a neighboring city, they may have a potential other bond requirements. They may not to where if you do need another bond outside of the city or potentially for the state, you would have to come back and get a different bond. This would only cover you within the city here. So I will print this out for you, and here is your bond.
All right, great. I see the bond form here. I don't understand what the second piece of paper you gave me.
This is the power of attorney. Yeah, so that does go along with the bond. Ultimately, this power of attorney is my authorization to issue and sign the bond for you. As you can see, I signed here on the front page of the bond there, and I'll have you sign there as the principal. And then you'll need to keep that power of attorney with the bond form as you take it down to the licensing department.
Okay, great. I think I got it.
Sounds good. I think that's all we need to do for today. So we will get this all wrapped up, and this will renew next year with your license, and we'll keep everything in a nice little bundle for you, and you should be all set.
All right. Thanks again.
Yep. Have a great day.
Okay, everyone. That concludes your introduction to commercial surety, and I again want to thank you for your time today.